Further hearing in the appeals, Littlewoods Limited and others against Commissioner of Majesty's Revenue and Customs.
Mr. Rabinowitz.
My Lords, before I turn to issue 2,
Yes.
your Lordships will recall that in the course of my submissions yesterday, I referred to the case of Quinterville.
Yes. The dog.
The dogs and the cats.
Yes.
My learned friend also was, I think, wanted to say something about it, no doubt in his reply. But in front of your Lordships, you should have a file in which you will find Quinterville.
Thank you very much.
Can I just show your Lordships
Of course.
the relevant parts? It's in the speech of Lord Bingham at page 695, the paragraphs 8 and 9. Paragraph 8 really gives a textbook statement of what
Yes.
the task of the courts is. I would emphasise, if I might, at E, the court's task within permissible bounds of interpretation is to give effect to Parliament's purpose. So the controversial provisions should be read in the context of the statute as a whole, and the statute as a whole should be read in the historical context of the situation which led to its enactment. Your Lordships will recall my submission about this, that Section 78(1) was intended to be residual to such other rights as the individuals, taxpayers already had. Then there's paragraph 9. I can just read that to your Lordships. There is, I think, no inconsistency between the rule that statutory language retains the meaning it had when Parliament used it, and the rule that a statute is always speaking. If Parliament, however long ago, passed an act applicable to dogs, it could not properly be interpreted to apply to cats, but it could properly be held to apply to animals which were not regarded as dogs when the act was passed, but are so regarded now. The meaning of cruel and unusual punishments has not changed over the years since 1689, but many punishments which were not then thought to fall within that category would now be held to do so. The courts have frequently had to grapple with the question whether a modern invention or activity falls within old statutory language, and there's a reference to Benyon. A revealing example is found in Grant and Southwestern and county properties, where Mr. Justice Walton had to decide whether a tape recording fell within the expression document in the rules of the Supreme Court, pointing out at page 190 that the furnishing of information had been treated as one of the main functions of a document. The judge concluded that the tape recording was a document. There is then, at paragraph 10, a reference to what had been said by the late Lord Wilberforce in his dissenting opinion in the Royal College of Nursing. And again, if I can just read part of this to your Lordships, perhaps the whole. In interpreting an Act of Parliament, it is proper and indeed necessary to have regard to the state of affairs existing and known by Parliament to be existing at the time. It is a fair presumption that Parliament's policy or intention is directed to that state of affairs, leaving aside case of omission by an inadvertence, this being not such a case. When a new state of affairs or a fresh set of facts bearing on policy comes into existence, the courts have to consider whether they fall within the parliamentary intention. They may be held to do so if they fall within the same genus of facts as those to which the express policy has been formulated. They may also be held to do so if there can be detected a clear purpose from the legislation, which can only be fulfilled if the extension is made. How liberally these principles may be applied must depend upon the nature of the enactment and the strictness or otherwise of the words in which it has been expressed. The court should be less willing to extend expressed meanings if it is clear that the act in question was designed to be restrictive or circumscribed in its operation rather than liberal or permissive. They will be much less willing to do so where the subject matter is different in kind or dimension from that which the legislation was passed. In any event, there is one course which the courts cannot take under the law of this country. They cannot fill gaps. They cannot, by asking the question, what would Parliament have done in this current case, not being one in contemplation if the facts had been before it, attempt to supply the answer if the answer is not to be found in the terms of the Act itself. Now, again, my Lords, in our respectful submission, so far as Section 78 is concerned, the genus, if I can put it that way, that we're concerned with, is the language which makes it clear that Section 78(1) is residual and supplemental to other bases upon which the HMRC might be made liable. And there is nothing in those words which is restrictive. And that's why we respectfully submit that what is said by Lord Wilberforce and indeed Lord Bingham in relation to dogs, although plainly applying to facts rather than causes of action, applies equally in our case. Subject to your Lordships, I should just mention, my learned friend has also identified another case, that's the Child Poverty Action Group case. Rather than deal with it now, I'm happy to deal with it now, but it may be better if I wait to see what my learned friend has to say about it before I address you on that. The only thing I would say at this point is that in that case, the court was dealing with what had been found to be an exclusive or exhaustive code. The question there was whether or not a cause of action at common law, which may not have been known by the legislature, should also be excluded by this exhaustive code. And the Lord Dyson, made clear that given that the code was intended to be exhaustive, the fact that they may not have been aware of the common law claim was neither here nor there. It was intended to be exhaustive. The Lordships will have in mind that in our case, Section 78(1) is expressly stated not to be exhaustive. It's expressly stated to be supplemental and indeed residual. And so, as I say, I'll wait to see what the learned friend has to say, but in our submission, the case is nothing whatever to assist your Lordships in relation to the present case. Can I then move on to deal with issue... I'm sorry.
Well, perhaps, can I just press you a little bit more on issue 1? Obviously, as you've explained, sections 78 and 80 were enacted at a time when the common law hadn't reached its current state of development. And so section 80 was envisaging a restitutionary claim in respect of overpaid tax being for the amount of the tax itself. And it provides a statutory means of recovering the tax, subject to what's effectively a passing on defence in subsection 3, with the statutory scheme and statutory instruments enabling a sort of pay-to-be-paid mechanism to be established. And also the shortened time bar of 3 years, which is presumably shortened in order to prevent public finances from being disrupted by the emergence of claims which are more than 3 years old. And section 78 then deals with interest distinctly and enables interest to be recovered, as you say, where it wouldn't have been recoverable apart from that section. And at the time that that was passed, Parliament would have been envisaging that there were alternative entitlements to interest under particular statutory provisions, for example, in relation to judgment debts. We agree with me so far?
Well, your Lordship says at the time Parliament would have been envisaging, it might have had in mind section 35, and it might have had in mind section, I think as it was, 85A or 84. Yeah. I accept that, my Lord.
Yeah. And then we have an important development in the common law, so that the enrichment of which restitution can be claimed at common law is envisaged as being not only the overpaid tax, but also the value of the use of that money during the time that the revenue had it. And the measure of that value is ordinarily going to be interest.
I accept that, my Lord.
Yeah. So if you then apply the legislation literally, there's at least an argument that the interest element of the restitutionary claim at common law does not fall within the scope of section 80, because it's not an amount mentioned in that section.
Certainly, I would accept. I would say go beyond that and say, even not, certainly literally, that would be the position. But just as a matter of conceptual, what English law recognises to be the claim, that would be the position.
Yeah. And Equally, on a literal construction of Section 78, the interest doesn't fall within the scope of that either, because it's an entitlement which exists apart from Section 78.
Indeed.
Yeah, and that's really your argument.
That is my argument.
And the difficulty that obviously has impressed the courts below is that on that construction, the consequence is that a restitutionary claim lies for the use value of the money, in other words, the interest on the money, which is not subject to the limitations imposed by Sections 78 and Section 80, in particular the time bar limitation.
My lord, yes, but bear in mind, you would have a claim for interest not subject to that limitation period whenever there was a claim for interest which fell within the language which makes it clear that Section 78(1) is residual.
Yeah. And the consequence then is, I think, that in every case of overpayment of VAT, there is likely to be a claim for recovery which falls outside the scope of Sections 78 and Section 80.
My lord, I accept that there is likely to be. I think my one caveat about that is that presupposes there would in fact be an available claim in unjust enrichment. And given one can't know all the facts of all the claims that might arise, there might be there might be change of position, defences, assuming those to be available.
Absolutely.
But I don't demur from what your lordship is putting to me that the effect of my argument would mean that Section 78(1) and the residual right that it provides either has a minimal or a zero application.
Yes.
I have to accept
that. That's really the point.
Yeah.
Now, is it not in that situation possible to argue that in order to give effect to Parliament's intention, the language used in Section 78 cannot be given a literal construction, but has to be construed differently?
My lord, in my submission, what the language in Section 78(1) makes clear is that it is intended to be a minimum requirement. Your lordship says, should we construe purposively? One has to put yourself into the position that the legislature was in 1991, and one has to keep in mind the difference between judicial legislation and judicial interpretation. In the end, as I think Lord Bingham says and Lord Wilberforce says, and indeed I think Bentham talks about nonsense on stilts, the idea that you can discern what Parliament's intention must have been otherwise than from the words used.
Well, I think Bentham was talking about inalienable human rights.
But even so, the idea that you can discern what Parliament's intention was otherwise than from the words used is, in my respectful submission, not a correct approach. In this particular case, if you go back to 1991 and you ask what Parliament must have intended purposively, it was to create a residual right. And it was to create a right which was additional to such other rights as there were, which made, or there might be, I would say, which made the revenue liable.
Yes.
So in my respectful submission, one can't ignore the words and one can't read into that language the kinds of limitations which the lower courts, not the lower courts, the courts at first instance have sought to read into it.
And so you would reject, really for those reasons, the argument that in order to avoid, as you say, rendering Section 78 of minimal or nil application, one should read the reservation as referring to the sorts of entitlements to interest which Parliament would have had in mind at the time when the legislation was enacted.
My lord, I would, and I would do it on. Can I make two responses to that? The first is by reference to Lord Bingham's dogs example. Now, I know he's talking about facts, but here we're talking about causes of action or claims. In my respectful submission, I would reject the application of that to this language, just because that would require not giving effect to the language that Parliament has used, and indeed the purpose, because the purpose of this was to produce a residual right. In other words, supplemental to such other rights as there were. Now, that was the purpose. The fact that there is an additional right, which Parliament did not recognise, which existed on some Blackstonian doctrine of declaratory theory, doesn't, in my submission, allow one to say, I can ignore that further right, and I can treat this language, which is very general and broad, as if it were not general and broad. Because if the purpose of the statute was, as I submitted, was simply to add an additional residual right to such other rights as might exist, that is its purpose. And if there is another right which might exist, which Parliament did not recognise, in my respectful submission, it would be frustrating the intention of Parliament to construe the words in a way where they exclude it. Can I just make this point? And it's a point I made before, but in my respectful submission, I understand the apprehension of your lordships in accepting my submission, because, as Mr. Justice Voss puts it, one can put it in any way one likes, it makes a nonsense of the provision. I understand that. This will not be the first time that this court has interpreted legislation in a way which has necessitated an amendment having to be made in order to, and it's not the court which would be making the amendment, but HMRC have it well within their power, to approach the government and say, this statute has now been interpreted in a way which allows taxpayers much too much interest, and we want you to do something about it. That is what they did consequent on DNG.
Well, it's not really so much that it allows taxpayers more interest. I haven't even mentioned the difference between compound and simple interest.
Right, a different route to interest.
Yes, it's rather that the scheme established in Section 78 and Section 80 is effectively compromised.
Well, your lordship says that. In effect, well, it depends how you see Section 78.1. Section 78.1 was intended to introduce a residual additional right. Yeah. I made the point yesterday, and I don't want to labour it, but there is no basis for the argument that Section 78 and Section 80 were always intended to operate together. They weren't. They were intended, Section 78 gives rights to interest in circumstances when Section 80 does not apply, and Section 80 gives a right to a repayment in circumstances where 78 is not going to apply. So I understand the apprehension of the court in this, but as I say, almost uniquely, the HMRC have it in their power, if they don't like the consequence of your lordship's interpretation of the words that Parliament has used in the 1991 Act, they can enact an amendment.
Subsection 3, do you want subsection 3?
And perhaps just for the sake of completeness, what do you say about the argument that that subsection 3 of Section 80 is intended to prevent the unjust enrichment of the taxpayer by a restitutionary claim, and that likewise, it could be said, is subverted if one accepts that a claim can be brought at common law for the use value element of the enrichment, even when the claim in respect of the money itself is barred by Section 80.
Can I respond in this way? The first point in response to that is subsection 3 plainly relates to an unjust enrichment claim in respect of the money itself.
Yes.
And it arises in circumstances where one is dealing with a party who is in a sense passed on, as I understand it, the VAT. Yeah. Now, that has that limited application in relation to that. In my respectful submission, my Lord, when you're dealing with the interest, it's difficult to see how a provision which relates to unjust enrichment in relation to the capital can affect a claim for the use value of the interest. Of course, if it were a common law and there was no unjust enrichment, then the claim in common law would fail for that reason.
But if the taxpayer passed on the tax to his customers, then he's not out of his money.
Well, the taxpayer's passed on the tax to his customers, but with respect, that wouldn't stop. That would be in relation to the money, in relation to having the use value of the money. He would still have lost the use of that money. Can I just?
We'll just say the price of his product, I don't know, because of that is, let's say it's £24 when it should have been £20. And so and what he does is to charge his customers the £24 and remits £4 to the revenue. Well, he's out of the £4 that he's remitted to the revenue, but he's got it in from his customers. I mean, that's what Section 80, subsection 3 is meant to address. So his net position is the same as it would have been if the tax hadn't been wrongly paid.
Well, my lord, it may be that would be a defence to a claim in unjust enrichment anyway.
Well,
because there may have been an enrichment, but in circumstances where the enrichment was not at the expense of the taxpayer because it's been passed on to someone else, then the argument would be it is not at your expense. So in my respectful submission, it is difficult to imagine a claim for unjust enrichment which would fail by virtue of subsection 3, where there wouldn't be a similar basis for a defence in relation to the common law.
Well, I mean, the courts so far haven't been prepared to accept a passing on defence of common law.
Well, it may be that this hasn't yet come up, but your lordship sees my point about this. If in fact I am not out of the money at all, but someone else is, it's very difficult to see why, although the revenue would have been enriched, it would have been at my expense. And indeed, I think this was a point that was made in ITC in the Court of Appeal. I know that's now battle long forgotten, but that was an argument I think that was being maintained there, that it wasn't at your expense because someone else, in that case I think it was the managers, had paid for that money. And in any event, my lord, your lordship is producing an argument in relation to the unjust enrichment defence, which doesn't find its way into Section 78 anyway. If this was something that the revenue were concerned about, or at least the legislature were concerned about, one would expect to find it in Section 78(1), so that by providing this basis for saying one is undermining the legislation, one is not undermining the legislation any more than Section 78(1) already does. And bear in mind, Section 78 can operate in circumstances where Section 80 doesn't.
Yes, but Section 78(1), if Lord Reid is right, would only operate as ancillary to the principal claim under Section 80 in this context. There wouldn't be a standalone common law claim. So one wouldn't expect to see a Section 80 subsection 3 in Section 78.
With respect, Section 78 doesn't only operate as an ancillary to Section 80.
It doesn't only, I agree, but in relation to when it is looked at along with Section 80, if there is the defence in respect of the principal sum, how would there be a claim under Section 78?
Well, if there is a defence in relation to the principal sum, then there would have been. Then there also won't have been a claim for unjust enrichment, because there wouldn't have been an overpayment. So on that basis, Section 78, my argument would not be giving a reason that should not be permitted, because there wouldn't have been on that basis an overpayment in relation to Section 80.
Thank you.
Can I then move on to issue 2?
Yes, of course.
Which is moving from the English statute to what European law says about this. And the essential question here, as your lordships know, is the interpretation of what the Court of Justice said in the Littlewoods reference.
Yes.
And I think your lordships has this, but just very quickly, for your lordships' note, Mr. Justice Henderson deals with this at paragraphs 253 to 310. I'm not going to take you there now. Core volume 2, tab 12, pages 500 to 520. The Court of Appeal then deal with it at paragraphs 51 to 108. That's Core Volume 2, Tab 12. And in our written submissions, we deal with this between paragraphs 54 and 100. That's beginning at internal page 17. And can I begin in relation to this part of the appeal, and of course this is my learned friend's appeal rather than mine, just by taking your lordships back to Mr. Justice Henderson's conclusions. And the reason I'm showing your lordships this is to simply identify how narrow is the scope of the issue that is currently before your lordships. If I can invite your lordships, I'm going to give you references in Core Bundle 2, but if you prefer Volume 9, I will give those as well. I was going to ask you to go to paragraph 302 in Mr. Justice Henderson's decision, Core Volume 2, page 518, in Bundle A9, tab 77, page 3087. Yep. And at paragraph 302, one has Mr. Justice Henderson saying this: my overall conclusion on the difficult question of the meaning of adequate indemnity test in paragraph 29 of the ECJ's judgment is that it requires payment of an amount of interest which is broadly commensurate with the loss suffered by the taxpayer of the use value of the tax which he has overpaid, running from the date of payment until the date of repayment. And so that is, if you like, the first step in the inquiry. And your lordship's note that the learned judge puts a gloss on the adequate indemnity test. He says the interest must be broadly commensurate with the loss, and I'll come back to that. But even after one has resolved that issue, that still leaves the question, what was the taxpayer's loss, and what was the statutory interest, and was the statutory interest broadly commensurate with it? In other words, this is a general theme of my submission, whatever conclusion one reaches as to what adequate indemnity means, you then have to apply it to the facts. You have to see what the facts are, and you have to ask yourself, on any conceivable meaning of adequate, was this an adequate indemnity?
But I mean, you're assuming that the test is adequate indemnity. I mean, that seems to be a rather important question, because it is part of the reasoning, but actually the test, arguably, is really about effectiveness and equivalence, which are the well-recognised tests.
With respect, in my submission, that is not right.
Well, we'll need to look at it.
We will. I'll take your lordships to it in detail. The test is adequate. Was there an adequate indemnity? And where effectiveness come in is that your lordships will have in mind that there is a difference in European law. I know this is something your lordships will have well in mind. There's a difference in European law between identifying the right and then identifying whether the remedies which any particular state provides in respect of those rights meet the requirements of effectiveness and equivalence. Now, put another way, effectiveness and equivalence don't tell you what the right is. They simply enable you to test whether the right which EU law gives a party has been dealt with properly, subject to principles of national autonomy, by the member state. Because as a matter of European law, the way it works is the European law identifies the particular right. It's then a matter for the member states to decide what causes of action are going to be available to enable them to enforce that right. And it's up to them to provide whatever cause of action they like. But those causes of action have to satisfy the tests of effectiveness and equivalence. So, and I'll come back to this in due course, because my learned friend, in a sense, abuses the doctrine of effectiveness by suggesting that that tells you what the right is. It doesn't. It simply ensures that whatever the right is, it is given a remedy which is effective. If I can.
I understand what you're saying, but you'll need to make that good.
Indeed. So in my respectful submission, and certainly this is the submission which the courts below have all accepted, what one is looking for here is to whether or not the remedy which has been provided by Section 78.1, and I assume against myself that your lordships are against me on that, whether the remedy that has been provided by Section 78.1 is in the circumstance of this case an adequate indemnity. And I'll come to develop why I say that is the test in a moment.
But before you do, I must apologise for taking you back to issue 1 for a moment.
Don't worry.
There's just a point has occurred to me which, out of fairness, I should put to you.
Thank you.
In Section 78, Parliament made the right to recover interest under that section conditional on there being an error on the part of the commissioners. I presume on your approach, the entitlement which you're asserting at common law would exist even where there has not been an error on the part of the commissioners, if the circumstances of the overpayment are nevertheless such as to give rise to unjust enrichment.
For example, a Woolwich claim.
Yeah.
Yeah. My Lord, that's right. In my respectful submission, that's not an argument against me. That would be an argument in my favour, because, again, it shows that there isn't an exact overlap between these two, Section 78 and the unjust enrichment claim. The unjust enrichment claim can arise in circumstances, your Lordship says, where there is an error, and indeed that's the basis upon which it's put here. It can arise in other circumstances.
Yes, or Parliament's established a scheme under which you have your Section 80 right to overpayment, even if there has been no error, but your Section 78 right, if that's what you're reliant on, would only exist if there had been an error. Whereas on your approach, you would have the right to interest regardless of whether there had been an error or not, if there had been an overpayment and there wasn't some other defence to an unjust enrichment claim.
I think that is right, my Lord, and I think one of the reasons that's right is that wouldn't come within sections, the section anyway, because the section only deals with giving a right to interest in relation to a situation where there is an error.
Yeah, that's right. Thank you. Thank you very much.
Back to issue 2. Right, I think, taking you through Mr. Justice Henderson, and I showed you paragraph 302. Then one has the learned judge between paragraphs 302 and 310 identifying or dealing with the question of whether or not there is an adequate indemnity.
And you say that's the correct question?
I do say that's the correct question, my Lord. That is the question which is posed by paragraph 29 of the Court of Justice's decision. I'll come back to that. So paragraph 303, I deal with this question briefly because HMRC did not advance any separate argument that it should be answered adversely to the claimant. And the question is, has the payment of simple interest provided Littlewoods with an adequate indemnity for the loss of the use value of overpaid VAT? I deal with this question briefly because HMRC did not advance any separate argument that it should be answered adversely to the claimants. At this stage of the analysis, if I interpreted the adequate indemnity test as requiring either a full indemnity for their loss or an indemnity commensurate with their loss, nothing which I say here should be read as prejudging any of the issues on quantum which I will have to consider in due course. Rather, what I'm now considering is the level of loss to Littlewoods against which the adequacy of the indemnity needs to be measured in order to found liability. And then in paragraph 304, Mr. Justice Henderson goes on to explain that although European law requires a comparison between the amount of interest paid and the taxpayer's loss, Littlewoods was content to prove the government's enrichment as a proxy for that loss. And one sees that Mr. Justice Henderson, about 4 lines from the end of paragraph 304, refers to the unchallenged evidence that whatever the use value of the money to the government, it would have been significantly higher to the claimants. Then at paragraphs 305 and 306, the learned judge explains the evidence of Professor Kay. He was the expert instructed by Littlewoods, and that evidence related to the quantification of the cost of the government borrowing. And he notes that Professor Kay's evidence was not challenged, and entirely understandably, Mr. Justice Henderson accepted that. And that then takes one to paragraph 307, where we get the results of the calculation. On that footing, and updating the figures to 31st of October 2013, in accordance with Professor Kay's supplemental report dated 15th of October 2013, the aggregate cost to the government of borrowing amounts equal to the overpayments amounts to 1.48 billion, which after deducting the simple interest paid leaves a net claim for compound interest of 1.2 billion. Littlewoods accept, however, that for the purposes of the adequate indemnity issue, it may be appropriate to take a different calculation period because the relevant question is whether the payments of simple interest at the time when those payments were made provided an adequate indemnity for the claimant's loss. I agree with that submission. On that basis, Professor Kay has recalculated the figures down to the respective dates of the payments of simple interest. This revised calculation yields an aggregate cost of borrowing of 1.1 billion, which after deduction of the simple interest paid leaves a net claim of over 833 million pounds. Now, so one has there, just looking at paragraph 307, the figure of 834 million pounds. That represents the difference between, on the one hand, the interest payments that were actually made, and on the other hand, the minimum amount of Littlewoods losses. And that, as your Lordship see from that paragraph, is calculated to the dates on which the statutory interest payments were made, because the question whether statutory interest payments were an adequate indemnity must be asked at those dates. Now, there's no appeal from any of these figures. And what one is therefore left with, and I proceed on the basis that adequate indemnity is the test, and I say that that's the test because when we get to Irimi, it's made absolutely clear that that is the test. That is the test that the court repeats in Irimi. So there's no question about that, but I'll take your Lordships through it. If you apply the adequate indemnity test then, as the learned judge ultimately does in paragraph 310, if you apply the adequate indemnity test, the question you have to ask yourself is that, is the payment that Littlewoods received of £268 million in respect of interest, and which leaves them short by some £834 million, an adequate indemnity? Put another way, my lords, is a payment of interest which comes to less than 24% of the loss that was required to be indemnified an adequate indemnity. That is what the facts are. And if I'm right about adequate indemnity being the test, then that is the test your lords should have to ask yourself.
Well, it all turns really on what you understand that expression to mean. And Mr. Justice Henderson took it in 303 to mean a full indemnity, or if it's something different, an indemnity commensurate with the loss.
He did. And as I shall show your lordship, that is consistent not only with what the Court of Justice says in Littlewoods, but it is also consistent with what the Court of Justice and indeed the Advocate General say in Irimi, and it is also consistent with what an Advocate General in a case called Wortman, that I'm going to take you to, also said was the test. The test is it commensurate? I said to your lordships earlier, when I took you to paragraph 302, your lordship saw the gloss, the broadly commensurate gloss that Mr. Justice Henderson put on the test. The Court of Appeal said it doesn't need a gloss, just apply an adequate indemnity test. When we get to Wortman, your lordships will see that the Advocate General in Wortman gives exactly the same gloss. He says, is it commensurate with a loss? And in my respectful submission, that is clear, but I'll take your lordships through it. So the question then is a payment in respect of the loss that comes to less than 24% of the loss adequate? Is that an adequate indemnity? In my respectful submission, actually, it doesn't matter how you interpret the word adequate. As I say, on Mr. Justice Henderson's interpretation, indeed on the interpretation of the Advocate General in Wortman, it certainly isn't adequate because it has to be commensurate. Adequate has a specific meaning here, and I'll come to show your lordships the case of Marshall, which makes clear what that meaning is. But even if you don't have that meaning of commensurate, it is difficult to imagine anyone in the real world thinking that 24%, less than 24% is adequate. And again, I repeat this, your lordships will see when we go through the Court of Justice authorities, they make it clear that your right to interest stands on the same footing as your right to repayment of the capital. Now, if that is the case, and we know the strength of the right to repayment to capital where the only defence is a passing on defence, the suggestion that 24%, less than 24% payment in respect of the repayment of the capital would have been enough. If those are rights on the same footing, how could it conceivably be thought that 25% in relation to the interest is enough? If those rights are on an equal footing, and I don't think my learned friend demurs from accepting that the Court of Justice has now made clear that those rights are on an equal footing, how can it possibly be right that 24%, less than 24% is right, is adequate? Now, can I then just take your lordships to Littlewoods? in the Court of Justice. And I'm going to begin, if I may. Your Lordships have the judgment. I'm going to stay in Core Bundle 2, unless your Lordships would like the references to the A bundles. It's also at A3 tab 34. I'm going to start with the Advocate General's opinion. That's Core Bundle 2, tab 12, beginning at page 582. In the A3 volumes, it's A3 tab 34, page 1407. Just by way of a prelude in relation to the opinion of the Advocate General, your Lordships will appreciate that we support the view of the courts below that the Advocate General's opinion is at this stage mainly of historical interest. But it is of interest in that it enables one to contrast the approach taken by the Advocate General here with the approach taken by the Court of Justice, which was plainly a rejection of the Advocate General's approach. And indeed, when we get to Irimi, one sees again, just to give you a forthcoming attraction, what happens in Irimi is that Spain and Portugal make submissions in Irimi, and they make it on the basis of what the Advocate General in Littlewoods said. And you'll see when we get there that Spain and Portugal's submissions in Irimi track what the Advocate General say. And they say as long as it's more than nominal interest, that's okay. That's rejected in Irimi. The Court of Justice says that that is wrong. But it is therefore of interest just to see what the Advocate General was saying in order to contrast it with what, in fact, the law now plainly is. So if I can invite your Lordships first, my learned friend took you to some of this, to go to paragraphs 11 to 13. In Core Bundle 2, it's at page 586. In the A3 volume, it's at page 1409.
Thank you.
And this, I would submit, helps to place the court's ultimate decision in context. In the view of the Commission, the first, second, and third question should be answered to the effect that where a taxable person is overpaid VAT, which was collected by the member state contrary to the requirements of EU VAT legislation, a remedy which provides only for reimbursement of the principal sums overpaid and simple interest on those sums is compatible with EU law insofar as that remedy provides adequate restitution or compensation for the loss of the use of the money, and insofar as no more generous remedy is available as a matter of national law in relation to other taxes. The governments of the United Kingdom, Republic of Cyprus, French Republic, and Federal Republic of Germany answer the first question to the effect that the remedy provided by a member state, which where VAT is collected in breach of EU law, provides for reimbursement of the principal sum overpaid and simple interest on those sums in accordance with national legislation, accords with European law. The Finnish government also answers the first question to this effect and states that regard must be had to the principles of effectiveness and equivalence. Similarly, the Netherlands government argues that the European law does not require the member states to pay compound interest in connection with the reimbursement of VAT collected in breach of EU law. Consequently, in the views of the government of the United Kingdom and the Republic of Cyprus and the Netherlands and Finnish governments, there is no need to answer the second, third and fourth questions. In answering the first, second and third questions, the applicants, that's obviously Littlewoods, in the main proceedings, take the view that the remedy which the member state must provide for reimbursement of VAT collected in breach of EU law must compensate for the benefit the member has received through the use of the principal sum collected in breach of EU law. It is for the national courts to determine whether, in addition to the reimbursement of the principal sum overpaid, the remedy should also provide for payment of simple interest, compound interest, or some other form of interest.
Just pausing for a moment. In paragraph 11, when the Commission submitted that a remedy which provided only for simple interest was compatible with EU law insofar as it provided adequate restitution or compensation, presumably I imagine they must have had in mind that it might not if the rate of interest was unrealistically low or if the period for which it was payable didn't reflect the true period when the person had been out of their money.
It's a question of fact, my lord, and there is no question but that compound interest only starts making a difference over longer periods of time. And obviously, if you have higher rates, then the fact that you don't have even simple rates, if you have a simple rate of interest at a high rate, that may do more than compensate for the fact that you don't have compound interest. So how the nation's member state is actually going to ensure that the payment is adequate will be a matter for the member state. It may be a question of higher rates, It may be that it has, so that you could have simple interest applying. It may be that you need compound interest. Can I just, on this question of simple and compound, just make this point? My learned friend, certainly below, and I think to this court as well, has suggested that there is some significance in the fact that the Court of Justice did not positively rule that EU law requires that compound interest be paid. But, my lords, and this is a point we've made more than once, no one was arguing that there is an EU law requirement to pay compound interest per se. And your lordship sees the way it is put in paragraph 13. It is for the national courts to determine whether, in addition to the reimbursement of the principal sum overpaid, the remedy should also provide for payment of simple interest, compound interest, or some other form of interest. And can I just show your lordships what it is what we were actually saying to the European Court? Because we weren't saying to the European Court there should be a right to compound interest. And so there is absolutely no point for my learned friend of the sort that he seeks to make, that there is some significance in the fact that the court did not say you're entitled to compound interest. Can I invite your lordships to go to our written observations to the European Court? It's in Core Volume 2 at tab 13, page 706. Paragraph 94.
Yep.
Just reading paragraph 94, page 706. As noted above, Littlewoods does not suggest that this court needs to specify the rate of interest or, if appropriate, the frequency of compounding that will satisfy the principle of effectiveness. These are factual matters that will differ depending on the circumstances of particular cases. This court can, however, rule on the principle that must be applied, viz., that a remedy must be given in respect of the use value that is commensurate with the benefit gained by the member state. It is then for the national court to determine what that principle requires in particular cases. And as your lordships can see, this, I would submit, is quite closely in line with the way in which the court dealt with the reference. If I could then just invite your lordships to go back to the opinion of the Advocate General in Core Volume 2 at 586, in the A3 volume at 1409, paragraphs 11 to 13, we submit that there is in fact a valuable point to be made in the opposite direction, that is to say the opposite direction to the point my learned friend.
Sorry, where are we looking now? The Advocate General?
Back to the Advocate General.
Back to 11 to 13.
11 to 13. If your lordship is in core bundle, it's at 587,
Yep. Okay.
A3 1409.
Thank you.
We submit that there is a valuable point to be made in the opposite direction. As your lordships saw, at paragraph 12, the United Kingdom positively invited the Court of Justice to conclude that a national law which provides only for simple interest complied with EU law. The lordship goes to paragraph 12.
Yep.
Your lordship sees that was the express basis upon which the UK made its submissions, that a national law which provides only for simple interest complied with EU law. And this, my lords, positively inviting the court to conclude that a national law which provides only for simple interest complied with EU law is something that runs throughout the United Kingdom's written observation. I'm not going to take your lordships to them now, or save perhaps for one reference, and then I'll give you the other references. If your lordships still have Core Volume 2, can I invite you to go to page 769, keeping your finger in the Advocate General's speech. 769 is the last page behind tab 13.
Yep.
Your lordships see paragraph 90. It begins at the bottom of page 768. So at the bottom of page 768, your lordships see paragraph 90. Question 1 should be answered as follows. Where a taxable person has overpaid VAT, which was collected by the member state contrary to the requirement of EU VAT legislation, the remedy provided by a member state is compatible with EU law if that remedy provides for A, reimbursement of the principal sums overpaid, and B, simple interest on those sums. Now that is, as I say, what they said throughout. Please say simple interest is okay. That's not what the European Court said at all. And just for your Lordship's references, in Volume 2, Tab 13, your Lordships, for your note, paragraphs 12, 14, 69 to 73, and 90. One has, again, this reiteration. Our position, says the UK, is that simple interest is okay. And my Lords, we submit that it's perfectly clear that the Court of Justice did not accept that submission. In effect, the Court was asked to endorse Section 78 as compliant with EU law, and they declined to do so.
What have the Advocate General said? Where is
I'm going to take your Lordship to that now. If I can, and perhaps this is... if your Lordships go next in the Advocate General to paragraph 30. Page 592 of Core 2. In A3, it's at page 1414.
Yep.
And just before I take your Lordships through that, just to put this into context, up to this point, the Advocate General, in this opinion, had been discussing the case law from the Court on interest. And what the Advocate General had identified, I'm not going to take your Lordship through it, is that there were two strands of that case law. An older strand, which treated interest as an ancillary matter. And as your Lordships might expect, the Commissioners had relied very heavily on those cases. That's at paragraph 27 of the Advocate General. But then the Advocate General also identified a newer strand, beginning with the case of Metallgesellschaft.
Yes.
And your Lordship see that's at paragraph 28 of the Advocate General, which didn't treat interest as ancillary. And then, as the Court sees, having identified those strands, one which treated interest as ancillary and one that treated interest as not ancillary, the Advocate General then reaches this conclusion at paragraph 30. In the light of these considerations, member states which have levied charges in breach of EU law must, in principle, according to the Court's more recent case law, both reimburse the charges levied in breach of EU law and pay interest in compensation for the unavailability of the sums paid. The taxable person, therefore, has a right to reimbursement of the charge and a right to payment of the interest. Those rights enjoyed by the taxable person are based on the provisions of EU law prohibiting the taxes levied. And as your Lordships will see, the Court reached the same conclusion. So far, so good. But then I would submit, at least as regards the Advocate General, things start to go wrong. And can I just, again, take your Lordships to, I think my learned friend took your Lordships through paragraphs 31 to 40. Applying the case law on the procedural autonomy of the member states, it is for the member state to lay down detailed substantive and procedural rules governing the taxable person's interest claims under European Union law. The member states are therefore entitled to determine the detailed rules relating to payment of interest, having regard to the principles of effectiveness and equivalence. Those detailed rules include the decision whether interest is paid on the basis of a system of simple interest or on the basis of a system of compound interest. It is clear from what is stated by the referring court that the United Kingdom has fulfilled its duty under European law to grant the person liable for VAT who is entitled to reimbursement and interest claimed. On the other hand, it is contested whether the United Kingdom has infringed the principle of effectiveness or the principle of equivalence in laying down the detailed rules governing the interest claims by granting payment of simple interest merely on the principal sum. In my view, the principle of effectiveness was clearly complied with. It is settled case...
I mean, on your position, 32 is a misstatement.
Your Lordships will see that the Court of Justice does not agree.
No, well, I want to be clear what you're saying.
Indeed.
Is where you're saying she goes wrong.
She goes wrong from paragraph 31 to 34, including at 32.
Right.
In my view, the principle of effectiveness was clearly complied with. It is settled case law that the principle of effectiveness prohibits the member states from rendering virtually impossible or excessively difficult the exercise of rights conferred by EU law. In the context of determining the detailed rules governing an interest claim stemming from EU law, a breach of the principle of effectiveness would therefore arise only if the interest were so low that it largely deprived the interest claim stemming from EU law of substance. And that is where you find the main error in the AG's opinion.
Very well. Thank you.
And my Lord, there are 2 points. Your Lordship sees that the AG asks herself what the principle of effectiveness requires, and her answer is that the principle will only be infringed if the interest is so low that it largely deprives the interest claim of substance. We would make 2 points about this. First, the test that the AG articulated, so low as to largely deprive the claim of substance, is quite clearly not the test that the Court of Justice chose to adopt in paragraph 29 of the Court's judgment. Second, as your Lordships will see, the AG's opinion on this point is, and we will look at this, reflected, and I've foreshadowed this earlier, in the arguments later advanced in Irimi by Spain and Portugal. And as I will show your Lordships, this was plainly rejected by the Court of Justice in that case as well. There may have been no coincidence given the timing of the arguments in Irimi. The arguments came in before the Court of Justice ruling in Littlewoods, but after the AG. In other words, when the parties were putting in their submissions in Irimi, the only thing they had was the Advocate General's opinion in Littlewoods. And so Spain and Portugal based themselves on what the Advocate General in Littlewoods had said, and the court basically slapped that down, as I shall show you. And we say that that is a very helpful indicator in deciding whether or not what the AG said at paragraph 34 does represent EU law. We say it plainly doesn't.
Right.
Then just going back to the Advocate General, following on from paragraph 34, she then goes on to explain in the paragraphs below that why applying her test, the principles of effectiveness is not infringed. And so in paragraphs 35 and 36, she refers to section 38 and she describes it. And one sees the reason she gives in paragraph 37. Pursuant to those provisions, the United Kingdom reimbursed to the applicants in the main provisions the VAT which had been obtained in the period between 1973 and 2004 in breach of EU law, amounting to approximately 204 odd million pounds, together with the simple interest amounting to 268 odd million pounds. Accordingly, the applicants in the main proceedings were granted a claim for payment of simple interest pursuant to Section 78 of the VAT Act 1994, under which the amount of interest accrued over a period of around 30 years, 268 million pounds, exceeds this principal sum, 204 million pounds, by more than 25%. In my view, that interest payment pursuant to Section 78 of the VAT Act readily complies with the principle of effectiveness. And one can quite understand, my lords, if your test is the test that the Advocate General posits at paragraph 34, a breach of principle of effectiveness would therefore arise only if the interest were so low that it largely deprived the interest claims stemming from the EU law of substance. If that is the test that you adopt, then one can quite see why, having posited the fact that she does in paragraph 37, she concludes that the UK was compliant. But my lords, as your lordships have seen, indeed I'll show your lordships, the Court of Justice articulated a different test. And given the nature of the different test that the court articulated, it is, I would submit, easy to see why the court was unable to draw the same conclusion from these factors. If the Court of Justice had considered that the factors on which the Advocate General had relied also showed that there had been an adequate indemnity, my lords, they would surely have said so. But that is not what the court has done. Instead, as we'll see, the court noted the factors on which the Advocate General relied and invited the referring court to take them into account in its evaluation of whether there had been an adequate indemnity. In effect, to take them into account along with all the other circumstances of the case. And on that front, my lords, perhaps I can just make this point before I move on to the judgment of the court. As your lordships know, we invite your lordships to interpret paragraph 29 of the Court of Justice's judgment as requiring a comparison between the simple interest paid and the losses. And on this approach, the amount of simple interest paid is plainly an important factor the court should take into account. It is one half of the comparison that is needed. And so it's not surprising that the court should indicate that this should be taken into account. And so, my lords, what is it that we submit this court is able to get out of the Advocate General's opinion? Well, the Advocate General and the court agreed that the EU law right to reimbursement of unduly paid tax includes a right to interest. So to this extent, they proceeded in company. But from that point on, my lords, they part ways. First, the Advocate General articulated a completely different test. That's a test in paragraph 34, which I accept the claimants would not be.
I don't understand, with respect, I mean, you're telling us the differences before we've looked at the European Court's decision.
Indeed.
And the principle of effectiveness and equivalence is precisely the test that the court lays down in the ultimate conclusion. I know we have this point about adequate indemnity which comes in, but to say that it's a completely different test when exactly the court uses exactly the same word seems to me it's like jumping ahead of yourself.
Can I then take your lordships to the Court of Justice and explain why I say it?
Because it seems that this is a crucial point.
Well, it is a crucial point.
Because you're saying the Advocate General got it completely wrong.
Indeed.
And you've got to show us how the court, because this is the reference of the case in these present proceedings, so presumably this is a guidance we're looking for.
I'm going to take your lordships to the court now, but just in summary, the Advocate General posits the test that you find in paragraph 34. A breach of the principle of effectiveness would therefore only arise if the interest were so low that it largely deprived the interest claims stemming from EU law.
Yes, that doesn't come in the court's judgment, I accept that. But
indeed,
effectiveness and equivalence is precisely the test the court adopts.
Well, let me take you to the court judgment, but just to be clear, effectiveness and equivalence are the way in which you test whether or not EU law, the EU law right, has been dealt with properly by the member state. They don't give you the substance of the EU law right.
Well, I know you say that, but I'm trying to look at what the court says, and you'll come to that.
Let me take you to the court rather than going around this. Your lordships have the court's judgment if you're in the core bundle, beginning at page 571, and A3, it begins at 1420. Yeah. And can I just invite your lordships to go in this straight to paragraph 23. Which is, as your lordship see, the second paragraph under the heading, the questions referred for a preliminary ruling. Paragraph 22 simply sets out the question. It should be noted as a preliminary observation, just picking up in 23, that as is apparent from the order for reference, in the dispute in the main proceedings, Littlewoods brought not an action for compensation based on infringement by the United Kingdom of EU law, but an action for repayment of the VAT levied in breach of that law. And then one has this. It is settled case law that the right to a refund of charges levied in a member state in breach of the rules of EU law is the consequence and complement of the rights conferred on individuals by provisions of EU law as interpreted by the court. And then there's a reference to St. George and Metal-Gesellschaft. The member state is therefore in principle required to repay charges levied in breach of community law. And then again references to Comatab and Metal-Gesellschaft and indeed FII as well. Paragraph 25. The court has also held that where a member state has levied charges in breach of the rules of community law, individuals are entitled to reimbursement not only of the tax levied, but also of the amounts paid to that state or retained by it, which relate directly to that tax. That also includes losses constituted by the unavailability of sums of money as a result of a tax being levied prematurely, and then there's a reference to Metal-Gesellschaft and FII. It follows from that case law that the principle of the obligation of member states to repay with interest amounts of tax levied in breach of EU law follows from that law. Now, just pausing there, my lords, your lordships see that the Court of Justice identifies the fact that this is a case for repayment. And then in paragraphs 25 and 26, your lordships see that the Court of Justice refers to the right here, the right that we're dealing with here, to be a right to reimbursement, not only a right to reimbursement of the principal amount of tax, but also a right to reimbursement of interests. Yep. And that is so, my lords, not only where the tax was charged prematurely, your lordships will recall that that was the issue in Metal-Gesellschaft, that was ACT. That was the position that the UK had been adopting all the way up to the Court of Justice in Littlewoods. They said you needed to draw a distinction between your right to interest, which they had to accept did exist where there was a premature payment of tax, but they said it didn't exist where there was no payment of tax that should have been made. The Court of Justice rejects that, and it makes clear that the same right to reimbursement arises also when the tax should not have been paid at all. And that is perhaps an obvious point, but of course HMRC was arguing to the contrary. And then in paragraph 25, your Lordship saw the express reference here to the loss constituted by the unavailability of the sums of money. I'll come back to that. It's relevant in relation to issue 6. And that we would submit tells one that what EU law is concerned with is the claimant's loss of the use value of money. And my lords, we obviously put a great deal of emphasis on paragraph 25 because it is here that the Court of Justice tells one what the content of the relevant right is. It is a right to reimbursement of the losses. Expressly says that.
The difficulty is that when one reads what they say in paragraph 25, but and I agree that that appears to be the implication of what they say, but then you have to reconcile it with what they go on to say in paragraph 27.
Well, can I let me read 27 and then make some submissions on that. Just looking at 27, in the absence of EU legislation, is for the internal order, legal order of each member state to lay down the conditions in which such interest must be paid, particularly the rate of that interest and its method of calculation, compound interest. Those conditions must comply.
Simple or compound?
Simple or compound.
Yeah.
I'm not sure what I said, but I apologise.
Sorry, I thought you just said compound.
No, sorry. Maybe I did. Those conditions must comply with the principles of equivalence and effectiveness. That is to say, they must be not less favourable than those concerning similar claims based on provisions of national law or arranged in such a way as to make the exercise of rights conferred by EU law, the EU legal order, practically impossible. Thus, according to the consistent case law, the principle of effectiveness prohibits a member state from rendering the exercise of rights conferred by EU the EU legal order impossible in practice or excessively difficult. In this case, the principle requires that the national courts referring...
That principle.
Beg your pardon?
I think you said the principle. It's that principle.
That principle.
In other words, it's the principle of effectiveness.
That principle requires that the national rules, referring in particular to the calculation of interest, which may be due, should not lead to depriving a taxpayer of an adequate indemnity for the loss occasioned through the undue payment of tax. So the way in which this runs is the court identifies your European right, which is a right to reimbursement. It then, in effect, says how you deal with your right is a matter for national autonomy, because the EU law does not tell you what causes of action you have to have available. That's a matter for the member states. In relation to the causes of action that you provide, they have to satisfy the principles of effectiveness and equivalence.
Yes.
But whatever your causes of action, if it is going to satisfy the principles of equivalence and effectiveness in relation to this right of reimbursement, you must ensure that what is paid is an adequate indemnity.
No. I mean, that way of putting it isn't right. I think this comes back to Lord Carnroth's point. Paragraph 29 is telling us what the principle of effectiveness requires in this context.
Well, it is saying...
That principle must be a reference back to the principle of effectiveness in the first line.
And it's sort of confirmed
I'm not disagreeing with that.
The opening of paragraph 31, which is where the court turns to the question of equivalence.
I'm not disagreeing with that at all. I'm accepting that what this says is you have a right to reimbursement. When you take it into national law, it's up to national law to work out what methods you're going to use. Are you going to use simple? Are you going to use compound? What you're going to do about it. But what the principle of effectiveness requires is that whatever methods you use, you must ensure that there is an adequate indemnity.
Yeah, well, no, with respect, it may be a different way of putting. What was confusing me was that you seemed to be suggesting that adequate indemnity was something separate from the principles of effectiveness and equivalence. It's quite clear here that the two principles are, indeed the Advocate General said, effectiveness and equivalence. The differences are in one is what is involved in the principle of effectiveness.
My Lord, I'm so sorry. We may have been at cross purposes. What I was...
I raised this point early on because I was wondering where we got on effectiveness, and I was told it wasn't an issue in this case, but it seems to me it clearly is.
Equivalence not, but effectiveness yes. Because we don't rely on the principle of... what effectively is being said here is the principle of effectiveness.
Yes. So your point is that the Advocate General took a too limited a view of what was meant by effectiveness.
too limited a view on what was required by the principle of effectiveness in circumstances where the right that one is talking about is a right to reimbursement. That is the issue between the parties. The learned friend's position, in effect, has to be that it is okay as long as what you get looks like interest. Our position is that that was a position rejected by the Court of Justice, not only here but in Irimi as well. And what the principle of effectiveness requires as a minimum in relation to the right of reimbursement is that you be given an adequate indemnity. And just to go back to it, the question is whether being paid less than 24% of one's loss is an adequate indemnity.
Why then do they go on to, not to refer to that rather striking point, but to refer to the fact that it's 23% more than the principal sum?
Well, who knows, my lord? Because that makes no sense at all.
No.
I mean, what is the relevance of being told that this is more...
Because you'd made this very striking point, that this is only 24% of our outward loss. And here they are saying, well, actually...
But what it suggests is that what they mean by, in the English translation, adequate indemnity, is not what an ordinary English speaker might understand by those words.
Well, I don't know why your lordship says that with respect, because this was a judgment delivered in the English language and would have been reviewed by Justice Sheeman before it went out. And there is no reason to assume that when they used the words adequate indemnity, they didn't mean that. And as I shall show your lordship when we go to Wortman, that's certainly what the Advocate General understood adequate indemnity to mean. He says it means a payment commensurate with the loss. And when you look at Irimi, it is impossible with respect to reconcile my learned friend's position with the conclusion that the court reached in Irimi.
But as you say, if
Perhaps you should ask them.
We can't go back there.
this was a Grand Chamber judgment, but if they meant that, then the remarks in paragraph 30 don't really make much sense.
The remarks in paragraph 30 are difficult. Every court has looked at this and said those are quite difficult to understand. They don't make sense on either party's position, because on my learned friend's position, he really has to deal with the fact that nothing in paragraph 30 even identifies the loss. Now, we're talking here about an adequate indemnity in respect of the loss. They've said that in paragraph 29. But the Court of Justice did not know what the loss was. So telling us, as the Advocate General had done, that if you compare the interest to the capital, it's a lot of money, tells you nothing at all about whether what you've been paid is an adequate indemnity in respect of the loss. With respect, the only sense that any court has been able to make of this, and it's not much, is to say what the Court of Justice was saying in paragraph 30 is that you had to look at all the circumstances of the case. To be fair to the Court of Justice, and indeed even to be fair to the Advocate General, they didn't know what the loss was at that point. So they couldn't take...
Yes, we haven't had Mr. Justice Henderson's
Exactly.
judgment.
They hadn't had that. So they couldn't actually say this was not...
You were presuming, I mean, was your evidence to similar effect?
Our evidence was to similar effect.
Yes, the Advocate General, I think, records the nature of the size of your claim in general terms.
That was
so they knew that you were claiming 1.1 billion or whatever. So they knew that your assertion of loss, which hadn't yet been established, was of that magnitude.
They certainly knew that the assertion, and that's all it was at that stage, it wasn't accepted, it hadn't been admitted. But with respect, that makes it even more difficult to, in a sense, give them the benefit of the doubt about this. Because how can you not identify what the loss was if you're just talking about an adequate indemnity in respect to the loss? The whole of this judgment is predicated upon look at the loss, compare it to something.
They also knew, I think we've been told, that the only country which didn't limit it to simple interest was Sweden, I think.
Well, my lord, on that, there was a submission which was made by my learned friends, I think yesterday, in relation to that issue. I should just say that the Lordship will recall Mr. Swift yesterday, I think just before lunch, gave you references to the UK's written observations, which canvassed the position in 13 member states. The report canvassing the practice in 13 other member states is one that the UK commissioned and then placed before the Court of Justice of its own motion. Now, that information was not tested, and the Court of Justice did not mention it. No. So there's no evidence that they consider the practices of other member states to be relevant. And I should just say this about it. At the resumed trial before Mr. Justice Henderson, HMRC adduced into evidence an expanded version of the same report, which now covered all 26 other member states. And you won't have noticed any reference to this because Mr. Justice Henderson didn't refer to it in his judgment, and there's a reason for that. We made submissions about the report in our opening submissions, and we made a series of points which were directed to showing that the point was neither relevant nor indeed reliable. I don't propose to say any more about this, but your lordships have in that bundle that my learned friend handed up, or maybe just on top of that bundle, an extract from our written submissions which identified respects in which, you don't have it. Separate and on top of the file you have something which begins at paragraph 476. I'm not going to take you through it, but it makes points as to why what was put before the Court of Justice, and certainly the English court, was...
But I mean, your main point is there's no evidence the court had that before them in any...
Or why it would be relevant. I think the point we made, my lord, some of those member states gave no interest at all, for example. So why the UK wanted to be allied with a series of transgressors, I don't know, but there was a great deal of variety, some people giving nothing at all, some people giving simple as well. But it doesn't really help in terms of what it is that European law requires. And we say what it is European law requires is made most evident by paragraph 25 to 29. Have regard to your lordship's point about effectiveness, and as I say, what we say is that the principle of effectiveness when you're dealing with a right to reimbursement requires at the least that you give an adequate indemnity in respect of the loss. Now, can I then mention this, my lords? Your lordships have been given two views about the source of the content of the right to interest, which the Court of Justice recognised in this case. The Court of Appeal considered that the Court of Justice specified the content of the right in paragraphs 25 and 26, where it indicated that the right is one to reimbursement of losses constituted by the unavailability of the money, and it is then that right which, on this view, the principle of effectiveness requires should be given effect by the national courts. Now, perhaps I can just show your lordships that. If your lordships have Core Volume 2, it's at page 335. I'm looking at paragraphs 93 to 96.
Which page?
335 in the Core Volume, my lord.
Thank you.
At the bottom of page 335, like the judge, we consider it is logically necessary first to identify the content of the right to interest now recognised by the Court of Justice. It is only then that one can answer the question of whether the UK's procedural rules in the form of section 78 of the VAT Act give effect to that right in a way which does not violate the principle of effectiveness. In other words, what is it that EU law requires UK law to remedy? Then paragraph 94, we consider it is now tolerably clear that the EU law requires national law to reimburse the losses occasioned by the unavailability of money as a result of tax being levied unlawfully. This is why the court is saying at paragraph 25 of its judgment in Littlewoods, at least in relation to the tax levied prematurely, and the distinction between such a case and one in which the tax itself is wrongly levied has plainly been abandoned. The use of the word reimbursement is, in our judgment, of great importance. We do not understand the court to be saying that EU law merely requires the provision of a remedy which meets the description of interest. That, as we read her opinion, is what the Advocate General had in mind when she speaks in paragraph 30 of a right to reimbursement of the charge and a right to payment of interest. This allowed her to conclude that the principle of effectiveness would be complied with, provided that it did not result in a payment so low as to be private of substance. The court's formulation is quite different. It says the taxpayer is entitled to reimbursement of the amounts paid to the state or retained by it, which includes losses constituted by the unavailability of sums of money. Thus, far from saying that the principle of effectiveness is complied with, provided that the resulting payment is not deprived of substance, the court says expressly at 29 that the application of the national rule should not result in the taxpayer being deprived of an adequate indemnity for the loss occasioned through the undue payment of VAT. The difference between the two approaches is stark. Under the Advocate General's approach, one would only ask whether the ultimate payment had substance. This consideration may well explain why she felt able to reach a clear conclusion. Your Lordship sees what's said there. So that's one approach to the identification of the content, the source of the content of the rights. The Court of Appeal says it's the right to reimbursement constituted by the unavailability, and as your Lordships know, we support that approach. My lords have heard from a learned friend a different approach to identifying the source of the content of the right. As I understood my learned friend's submission, his submission is that a right to interest is recognised by EU law. He accepts that. But he says the content of that right is to be specified by national law so that the right may have a different content in different member states. They have, according to Mr. Swift, member states do, considerable latitude, although he notes the member states are constrained by the principles of effectiveness and equivalent, which he says provide a minimum content to the right. Mr. Swift even said the principle of effectiveness is limiting, which is a concept we've never seen before and don't quite understand. But so far as we understand Mr. Swift's submissions, the content of the right, on his case, seems to come from two sources. And this is all about trying to say the content of the right is not a right to reimbursement. He wants to move your lordships away from considering that that is the right. He says the right comes from two sources. First, he says the principle of effectiveness and equivalence, which he says sets a minimum content. And second, he says, from the member states, who he says are free to specify the content however they wish, subject only to that minimum content. Now, my lords will already appreciate a number of the grounds on which Littlewoods disagrees with this view. At this stage, I just want to make a point about the conceptual coherence of my learned friend's approach. Now, looking first at the principle of effectiveness, I'll ignore the principle of equivalence for the moment because it is not in play. We submit, my lords, that HMRC's submission ignores the distinction between the content of a right and its enforcement. The principle of effectiveness requires that member states should provide an effective remedy for violations of EU law rights. It is about ensuring effective enforcement of those rights in circumstances where the member states have procedural autonomy. But one can only apply that principle once one has determined at a logically anterior stage what the content of the right in question is. One has to know what it is that the member state is required to give effect to. The principle of effectiveness cannot be used to give the right content. That would be, with respect, back to front. And so what we find in the Court of Justice's judgment is that they specify the content of the rights as
We're going back over the same ground.
Indeed.
In this case, they treat the question of the adequacy of the amount as an aspect of effectiveness. Now, that may mean that they're sort of merging the two together, but you can't say that they're treating them as different things.
No, I'm not saying that they... But the right is a right to reimbursement. It's very important that one recognises what the right is, which you have to give an effective remedy for. The right is a right to reimbursement. Now, the background to all this, of course, is the Advocate General saying, oh, it's okay as long as you give something which looks like interest. And the Court of Justice is saying, no, no, no. You have a right to reimbursement here. And what the principle of effectiveness requires is that you give an adequate indemnity in respect of the loss. And that's where my learned friend and I part, because my learned friend doesn't want to recognise that the right that you're having to give effect to and that the principle of effectiveness is seeking to ensure is effective is the right to reimbursement. That's where we differ. And that's the point that I was trying to make, my lord. So I don't think I need to go over that. I just need to deal, I think, with the next part of my learned friend's position, which is to his position, as I've said, is to say the content of the right is provided by the principle of effectiveness. That makes no sense at all. Plus, he says it's left to the member state. Again, with respect, the problem about leaving it to the member states is that's exactly what the Advocate General said. And we know that the Advocate General was not followed. Plainly in Littlewoods and plainly again when we get to Iremi. So my learned friend's idea that the content of the right is left to the member state as a matter of procedural autonomy, we might have been able to say that before the Court of Justice and after the Advocate General. But after the Court of Justice, and certainly after Iremi, he's simply not open to him to say that. Anything else? Now, yeah. My Lord, when Mr. Swift dealt with this, what he said was that where one was dealing with the overpaid principal amount, the right to repayment, he said, when you're dealing with the overpaid principal amount, he said it was self-executing. And he meant that it was obvious that the principle of effectiveness requires repayment of the whole of the principal amount. When it came to interest, effectively, you could just give anything as long as it wasn't nominal. With respect, that doesn't make sense. If the rights are on the same footing, which the Court of Justice has made clear it is, then why should interest be treated differently? The position with interest is no different than the position with So, my Lord, that is what we say about paragraphs 29, and I've already made my submissions about paragraph 30. But can I just pause there to make this point? Littlewoods, as your lordships will see, is regarded as a very important case by the Court of Justice. In a way, Littlewoods is the Court of Justice's equivalent to Sempra in this jurisdiction. The significance of Sempra in this jurisdiction was that it recognized for the first time that a right to interest is a right of substance. It is not just something you get as a bonus. It is a right which has as much vitality and substance as the right to repayment of the capital itself. A pound is a pound is a pound. And Littlewoods, in the Court of Justice, does exactly the same thing for European law. It recognizes that the right to interest is in no respect inferior to your right to repayment of the capital. And the question that one then has to ask oneself is that if that is the position, how is it that an indemnity in respect of less than 24% is sufficient? We know that when you're dealing with repayments of the principal, the Court of Justice is very careful to ensure that the principal is repaid in full. There is only one defence that the Court of Justice recognises in relation to claims for repayment of overpaid tax. And that is the passing on defence. Why would it be the case that when you come to interest, it adopts such a different approach? My Lords, in terms of the language that one finds used in paragraph 29, your Lordships see that the Court of Justice in paragraph 29 uses the words indemnity, and it uses the words adequate as well.
Yes.
And your Lordships may have noted that Mr. Justice Henderson, let me put it this way, the Court of Appeal thought that the word reimbursement was of great importance. We would respectfully submit that the same might be said of the word indemnity in paragraph 29. They are both, we would say, very strong words. And we would say, my Lord, that they are consistent only with the position we put. Now, can I then just say, that, in relation to these words, your Lordships will have seen at paragraphs 27 to 30, Mr. Justice Henderson deals with the meaning of the words indemnity and loss in his judgment. And your Lordships may recall what he says about that. If I can just show your Lordships paragraph 294 of the judgment, that's volume 2, page 516. If you're in the A9 bundle, is at 3085.
Yes.
Page of the,
516 in the core.
Oh, the core, yeah, the core. I'm in the core.
So in the core, 516.
Okay.
Just looking at paragraph 292. The relevant meanings of indemnity in the online version of the Oxford English Dictionary, 2nd edition, compensation for loss or damage incurred, indemnification, and 3b, a sum paid by way of compensation. The relevant meaning of adequate is fully satisfied, what is required, quite sufficient, suitable, or acceptable in quality or quantity. In certain contexts, such as school reports or satisfaction questionnaires, adequate may be a term of faint praise connoting the achievement of a middling but barely satisfactory standard, That is the dictionary meaning 3b, satisfactory but worthy of no stronger praise or recommendation, barely reaching an acceptable standard, just good enough. In my judgment, however, that cannot be the meaning which the court intended in paragraph 29, especially when coupled with the noun indemnity. If I'm right thus far, it is clear that the approach and conclusion of the court cannot be correct. I'm not sure we need to worry about that. I just wanted to show your lordships those passages. In our respectful submission, Mr. Justice Henderson was right about that as well. And he was right about that, my lord, because in light of the strength of the protection accorded claims for principal amounts of overpaid tax, it is hardly likely that the Court of Justice intended anything less for interest claims. Moreover, we say, my lords, that having in paragraph 25 taken the step of recognizing that there is a right to interest that ranks equally with the right to repayment of principal amounts, the court would then go on to use the word adequate in the sense of meaning barely satisfactory. And that is the point that Mr. Justice Henderson makes at the end of paragraph 291. Now, in his written case, my learned friend had an argument to the effect that what the Court of Justice was interested in was saying whether Section 78 generally gave an adequate remedy. It's not a point that he has pressed, but in our respectful submission, just to deal with it very quickly, it is, with respect, hopeless on what the Court of Justice found in paragraph 29 and 30. It's pretty plain that the Court of Justice was interested in the facts of this case. It keeps talking about the facts of this case. There is no suggestion anywhere that it is interested in a generic study of whether, a general study as to whether Section 78 in the vast run of cases would produce an adequate indemnity. And the question that one has to ask oneself is this. If your lordships come to the conclusion that in this particular case, Section 78(1) does not give an adequate indemnity because it indemnifies only in respect of 24% of the loss, why does it help to say that in general terms, Section 78 would give an adequate indemnity? It simply doesn't deal with the point that the Court of Justice was on. My lords, your lordships may wonder where the word adequate has come from in the Court of Justice's reasoning, or indeed where the Commission found the word adequate. In that regard, it may just be helpful to take your lordships to a case called Marshall that we have in the volume. That you'll find at volume A3 at tab 37.
Yep.
One of three other cases I'm going to take you to. I'm going to take you to Marshall, then Irimi, and then Wharton. So A3 tab 37. My lords, before I take you through the detail of Marshall, the reason we submit that Marshall is interesting is because it illuminates the concept of adequacy when used in connection with the principle of effectiveness. It is the only case that was before the European Court of Justice in Littlewoods where the word adequacy was used, and it is a case which features a great deal in the submissions of Littlewoods, and indeed it features in the submissions of the commissioners, and indeed it features in the commissioner's decision as well. And so it is, we respectfully submit, illuminating to see the meaning that the Court of Justice in Marshall gave to the word adequacy. Now, the case is a little bit involved because the significance of the Court of Justice's judgment is only really clear when one sees what the Advocate General in Marshall said, and in effect what the court disagreed with. Just on the facts, very briefly, Mrs. Marshall had been the victim of sex discrimination and had applied to the Industrial Tribunal for compensation. Essentially, the applicable statute, Section 65(2) of the Sex Discrimination Act, imposed a cap of £6,250 on the compensation that could be paid. And that was about 1/3 of Mrs. Marshall's loss, inclusive of prejudgment interest, which the Industrial Tribunal had assessed at £7,710, applying Section 35A of the Supreme Court Act. And one of the questions for the court was whether the cap was consistent with the principle of effectiveness. The issue, as I say, is therefore structurally similar to the issue in the present case. And that is because, as the courts below have interpreted Section 78, it effectively imposes a cap on the interest that can be paid, limiting interest to an amount which is less, in this case at least, than the loss that the taxpayer suffers in being left out of his money, indeed less than a quarter of the losses. Now, the report of Marshall in the European Court that we have starts with the Judge Rapporteur's report, then includes the Advocate General's opinion, and finally the decision of the court. And if I can briefly take you to all three, just starting with the Judge Rapporteur, if I can invite your Lordships to go to 1474. One gets here a summary of the written observations, and this we would submit is helpful because it highlights how similar the issues in that case were to the issues in the present case. And so first we get Mrs. Marshall's argument from 132 to 133E, sorry, 132F, 133E, and perhaps I can just read.
Internal numbering, right, yeah.
Beg your pardon, my Lord?
Internal numbering, yeah.
Internal numbering.
Yep.
According to the applicant, the preliminary questions essentially raise three issues. First, the right to an effective remedy against the state or an emanation thereof in the event of discrimination prohibited by the directive under Articles 5, 1 and 6. Secondly, the adequacy of the compensation in relation to the injury suffered. And thirdly, what should be the response of the national court to national legislation which imposes limits on compensation. The principle of effective judicial protection requires the member states, by virtue of the obligations imposed on them by Article 5 of the EEC Treaty, to adopt all measures necessary to ensure that rights derived from the community legal order are effective and embraces not only procedural guarantees, but also substantive guarantees such as effective remedies for wrong. And your Lordship see a reference to Coulson, among other cases. As regards the adequacy of the compensation, the applicant considers that sanctions for breaches of community rights must be effective, proportionate and dissuasive, the effectiveness principle. In particular, they must punish breaches under conditions both procedural and substantive, which are analogous to those applicable to breaches of national law of similar nature and importance, the comparability principle, and that Lordship will recognise as the effectiveness and the equivalence principles. She refers to San Giorgio in that connection. In assessing the effectiveness of the sanction, regard must be had to the objectives both of the directive, namely the elimination of discrimination, and of an award of compensation in tort, which is intended to place the plaintiff so far as possible in the position which he would have been had the tortious act not been committed, the principle of restitutio in integrum. Specifically with regard to the directive, the court held in the Van Coulson case that a sanction must in every case, in order to be effective and dissuasive, be adequate in relation to the damage sustained. In the present case, any amount lower than the full amount of compensation calculated and awarded by the industrial tribunal would fail to place the applicant in the position which he would have been in if she had not been the victim of unlawful discrimination, would fail to achieve the object of equality of treatment, and would fail to provide an effective deterrent to employers in the position of the health authority, who might calculate that it would be cheaper to dismiss a woman in breach of the directive than to continue to employ her. That applies also to interest, to which the industrial tribunal was not empowered to grant, but without which any compensation would be inadequate, having regard to the damage sustained and the long delay before compensation awarded was actually paid. Moreover, the obligation to pay interest on the amount of compensation is a general principle common to the legal principles of member states. And if I could just pick it up from 133G, 1475G. Finally, relying on the case law of the Court of Justice, which has established the principle that a national court is obliged to set aside rules of national law which would prevent it from taking such measures as are necessary to ensure the full effectiveness of rights deriving from community law, the applicant submits that the industrial tribunal is obliged to award her the compensation which it assesses as adequate to remedy the breach of her community law rights, setting aside, where necessary, the provisions of domestic law which would otherwise prevent it doing so. In the alternative, having regard to leasing, the industrial tribunal is obliged to construe the relevant provisions of domestic law as if the power to award interest were conferred on it and the limit as to compensation were absent. And then you get the health authorities' arguments, and if I can just take your Lordships through this, start from A and go to F. The health authority contends that the requirement of Article 6 of the directive do not preclude the imposition by national legislation of some monetary limit on the amount of compensation recoverable in respect of unlawful discrimination, provided that the compensation available is sufficient to provide real and effective judicial protection and to have a real deterrent effect on employers. it is clear from von Coulson that the requirement that compensation should be adequate was regarded as a consequence of the requirement that the sanction chosen by the member state should be such as to guarantee real and effective judicial protection and to have a real deterrent effect. It cannot be said that the remedies available under the Act of 1975 are not a form of real and effective judicial protection, and it cannot be said that the compensation available is limited to a purely nominal amount, as it was in the Van Coulson case. With respect to comparability, I don't think we need to read that paragraph, just picking it up at E. The health authority emphasises that the directive makes no provision for the measure or quantum of compensation to be awarded in cases of unlawful discrimination, and likewise sets no standard by which to measure the adequacy of the money value of the compensation against the extent of pecuniary and non-pecuniary loss sustained. The only workable standard is the general principle that the judicial protection provided must be effective and that the sanction must have a dissuasive effect. Judged by those standards, the remedies provided by the Act of 1975 with a ceiling which is frequently updated are in conformity with the directive. So that's the health authority. We then have the United Kingdom over the page, so internal page 135, beginning at E.
I mean, what the point of referring to all this is that the issue of adequacy was right at the heart of the
Right
discussion.
at the heart. And
Yes.
the Lordship sees that the health authority was effectively taking the position that the commissioners are taking now. That adequacy means something, as long as it's not nominal, it's okay.
And you say the court rejected that.
The court rejected that. Mr. Elliott says I should just move on quicker and just make the point.
I wasn't.
Well, that's...
He can say that. I could
critic.
possibly comment.
136 at B, your Lordship sees a reference to St. Georgia, which again, it lies at the heart of what we're talking about here in terms of the rights. So St. Georgia was very central there as well. And that was obviously a case which was relevant in connection with tax cases. So lest it be said that this has got nothing to do with tax cases, the root of the right, the European law right, is the same. Now, your Lordship sees that the arguments were very similar. The issue was squarely presented as one concerning the principle of effectiveness, and it centred on, to some extent, the St. Georgia line of cases. Now, when you go to the AG's opinion, beginning at page 1483, if I can invite your Lordships to go to 1487, which I think is where we can pick it up. In this part of his opinion, 1487, the Advocate General has been discussing the question as to whether Article 6 of the Equal Treatment Directive has direct effect. And if I can just read paragraph 8.
Can I just ask you what in reality the argument was about? That this was a woman who was forced to take retirement earlier than a male colleague would have had to do. So she's lost earnings, and she's claiming for her lost earnings and also, I think, for interest on the for the period of the loss. And there's a cap which is set at a fraction of her losses.
Well, it leaves a third unsatisfied, and there's no interest at all.
Yes,
So-
she can only get about a third of the lost earnings, and she can't get any interest.
Exactly. So she can get about 6,000 instead of the 7,000, I think the figures were. I gave them 6,600 instead of 7,700. So effectively, you have there a cap in exactly the same way as we have a cap here.
Yes,
Yeah, it's 6,000 compared to 20,000 pounds.
yes, that's right.
Now, if I can just take your Lordships to paragraph 8 of the Advocate General on page 1487, the third paragraph of Article 189 of the EC Treaty leaves the Member States free to choose the forms and methods of the implementing directives. As regards the 1487C, I'm sorry, paragraph 8. As regards the obligation to impose sanctions contained in Article 6 of the directive, the Court has stated in the Van Coulson case and the Harts case, such measures may include provisions requiring the employer to offer a post to the candidate discriminated against or giving the candidate adequate financial compensation backed up where necessary by a system of fines. However, the directive does not prescribe a specific sanction. It leaves Member States free to choose between the different solutions suitable for achieving its objective. This freedom on the part of the Member States is not, however, unlimited. As is pointed out in the passage quoted in the preceding section, it follows from the purpose of Article 6 of the directive that Member States must provide for an appropriate system of sanctions. This entails, as the Court goes on to say in the Van Coulson case and the Harts case, and then we have this, that sanction must be such as to guarantee real and effective judicial protection. Moreover, it must also have a real deterrent effect on the employer. it follows that where a member state chooses to penalise the breach of the prohibition of discrimination by the award of compensation, that compensation must in any event be adequate in relation to the damage sustained. In consequence, it appears that national provisions limiting the right to compensation of persons who have been discriminated against as regards access to employment to a purely nominal amount, such as, for example, the reimbursement of expenses incurred by them submitting in connection with the application, would not satisfy the requirement of an effective transposition of the directive. And just pausing there, your Lordship see, in the quote from Van Colson and Hartz, the concept of adequacy is introduced. It is said that compensation must be adequate in relation to the damage. And as I shall show your Lordships, the advocate and the court disagreed about what that meant, just as they did. Well, they didn't in this case, because only the court used the concept of adequacy. But what one sees what the court meant here. If your Lordships go next to page 1492, bundle page, near the top of page 1492, internal page 150, your Lordship see that the Advocate General comes on to a new topic, whether the statutory cap on compensation is compatible with the directive. And if I can just read your Lordship's paragraphs 14 and 15. Section 65 of the Sex Discrimination Act provides that an industrial tribunal can make an order requiring compensation to be paid where it finds a complaint relating to sex discrimination in employment is well-founded. Under Section 65(2), however, the amount of such compensation may not exceed a specified limit. When the applicant's complaint was considered by the industrial tribunal, that limit was £6,250. Since then, it has been increased on several occasions, so it now amounts to £10,000. In its first question, the House of Lords wishes to establish whether such an upper limit is compatible with Article 6 of the Directive. In its second question, it asks whether it is essential to the due implementation of that article that the amount of compensation to be awarded should not be less than the amount of the actual loss found to have been sustained, and that it should include an award of interest on the principal amount of the loss from the date of the unlawful discrimination to the date when compensation is paid. Before answering those two questions...
Well, what are we looking for? I mean, we seem to be reading an awful lot of this, which we can read for ourselves. What are we actually looking for?
Just to see how the Advocate General...
I mean, he's clearly dealing with the question of adequacy, and you say it supports your case.
Indeed, indeed. So,
do we need to read quite as much as...
Well, if I can just invite your Lordship to go to over the page, to page 151, where one gets, in a sense, the nub of what the Advocate General concludes. If you look at D... Does your Lordship see, by stating in any event the compensation should be adequate in relation to the damage sustained, the court wished, on the contrary, to make it clear that nominal compensation was not enough, as is clear from the passage immediately following. The fact that the compensation should in any event be adequate in relation to damage sustained must mean, in my view, that the court in the present state of community law, and therefore in the absence of rules harmonising the divergent national rules, is prepared to accept less than compensation for the full damage sustained. In other words, the compensation must be adequate in relation to damage sustained, but does not have to be equal to. If you then go to what the court found...
So you're saying that's not adopted by the court?
That's not. That's the court disagrees with the Advocate General there. The court's judgment begins at page 161, internal page 161, bundle page 1503. But if your Lordships go to 1506,
Yep.
it's really paragraphs 22 to 26. And I'm just going to read. Can I ask your Lordships to mark that? I'm just going to read paragraph 26.
But you want us to bear in mind the lot.
Please.
Okay.
Paragraph 26. The financial compensation is the measure adopted in order to achieve the objective indicated above. It must be adequate in that it must enable the loss and damage actually sustained as a result of the discriminatory dismissal to be made good in full in accordance with national rules.
Yes. One notices that at the end of 24, they make the point not just judicial protection, but a real deterrent effect on the employer. Doesn't one?
Well, indeed, but my Lord, that is effectively what lies behind the rules which now exist in European law to ensure that member states do not extract tax which is not due.
So basically, the real deterrent point applies to any case where the state has done something or permitted something to be done.
Precisely. One has to ensure that the state doesn't hang on, is not allowed to hang on to a benefit which it wrongfully obtained. And that would be true whether it's interest or capital.
Yes, I see.
So, your Lordship see then what happens in paragraph 26. Adequate here is taken to be a payment in full.
It's a slightly different. I'm just looking at the Commission's written submissions in the present case, and I see that they say Marshall's distinguishable because Marshall was concerned with discrimination, and therefore it's in the nature of remedying discrimination that you have to level up what the woman's position was with what it ought to have been if the directive had been complied with. Whereas in the present case, we're not dealing with a situation of comparability in the same way.
But it does get followed in Metal-Gesellschaft. Marshall then becomes relevant in Metal-Gesellschaft. Whatever the Commission says, in Metal-Gesellschaft, they actually rely on Marshall for saying you have to disgorge interest because it matters to ensure that there is this playing field, that the playing field is made level. So they're reading across this generic principle into the tax and interest cases. Now, I ought just to make this point before I leave Marshall. In Marshall, your Lordship will see that the court there awarded simple interest rather than compound interest. And lest my learned friend seek to make a point about that, we would just note that no one in that case was saying that simple interest meant you didn't get an adequate indemnity. No one was saying that simple interest doesn't produce full compensation. So that's the court there was able to just deal with simple interest without getting into...
The point wasn't a live one.
Exactly. That would be a shorter and more accurate way of putting the point. So, my Lord, just in terms of Marshall, you have, as your Lordship see, a continual reference to the concept of adequacy and indeed to what it means. And then you have in the, as I said earlier, Marshall was the only case which was put before the Court of Justice where one does find this term adequacy used. And the question, therefore, is this. There are two possibilities. Either the Court of Justice in Littlewoods cut the adequacy criterion from whole cloth. That is to say, it just made this up without regard to any prior learning. Or, in using the adequacy formulation, the court had in mind what the court itself had previously said about the adequacy criterion in Marshall, and before that in Von Colson and Hartz, developing its case law as a coherent whole. And, my Lords, we submit that when one looks at the matter in this way, Mr. Justice Henderson was right to interpret paragraph 29 in light of the court's earlier decision in Marshall. Your Lordships may recall Mr. Justice Henderson dealt with the court's decision in Marshall at paragraph 276, and perhaps I could just show that to you. It's page 510 in the core bundle. In the A9 volumes, it's 3080. Mr. Justice Henderson begins to deal with Marshall at paragraph 276. He reaches his conclusions in relation to Marshall at paragraph 279. And perhaps I could just read your Lordship the first three subparagraphs of 279. The decision of the ECJ in Marshall is of interest for several reasons. First, it shows that in the context of Article 6 of the Equal Treatment Directive, the ECJ equated financial compensation which is adequate with compensation which makes good in full the loss and damage actually sustained by the claimant. In this respect, the Court was departing from the views of the Advocate General, Van Gerven, who expressed the view that compensation could be adequate even if it was for less than the full damage sustained. Secondly, although Marshall is not referred to in the judgment of the Court in the present case, the Court will have had in mind the claimant's references to it in its written observations. And thirdly, the references in paragraphs 26 and 30 to adequate compensation and adequate representation may have suggested the use of the phrase adequate indemnity. As I pointed out in Portfolio Dividends, the concept of an adequate indemnity appears to have no precursor in the case law of the ECJ in the field of taxation. It is therefore of some relevance to know that the ECJ has used similar language with the connotation that adequate compensation must mean full compensation in a broadly comparable context where the provision of effective compensation for breach of a fundamental principle of EU law was an issue. Now, I've said, my Lords, that Marshall was central to the arguments presented by the Court, and the Court must have had it in mind. Can I just give your Lordships the references to this rather than take your Lordships to it in the interest of time? Core volume, they're all in, starting first with the Littlewoods submissions, which begin at page 666. If I can just give your lordships or read them into the transcripts. Note 49 on page 689, paragraph 64 on page 694. There's a reference to the AG's opinion at paragraph 96 on page 707. There is on paragraph 101, page 709, paragraph 102 as well. There's a discussion of Marshall which continues at paragraphs 105 to 107, on pages 711. The Commission refers to Marshall as well. I think my Lord Reid has referred to that. That begins at page 726. Paragraph 15 at page 731. They refer to Littlewoods submissions, and they refer to Marshall. They refer to Marshall again at paragraph 27, page 734, and paragraph 28, and at paragraph 32. And the United Kingdom, the Commissioners, which begins at page 738, the reference to Marshall, your Lordship will find at paragraph 58 on page 758. So, my Lords, we respectfully submit that that is illuminating in terms of what the Court of Justice was likely to have had in mind, not just because of what we see in paragraphs 25 and 26, but also because of what was said in Marshall. Can I next take your Lordships to Irimi? Your Lordships have Irimi at volume A3, tab 32. I think my learned friend took your Lordships to the head note just to get the facts. 2007, the applicant purchased a motor vehicle registered in Germany. In order to register in Romania, she paid a pollution tax, the sum of 6,000 units. On 31st of August 2009, she brought an action before the regional court seeking an order for requiring repayment of the sum by way of pollution tax and the interest on that sum from the date of payment of that tax. Certain provisions of national law provided, however, that interest on sums to be repaid from public funds was granted only from the day following the date of the claim for repayment. An issue arose inter alia as to whether such a rule was consistent with European law. So just pausing there, I think the first point to make about Irimi, as your Lordship sees, is that it was a judgment given after Littlewoods, 13th of April 2013. Littlewoods was 9th of July 2012.
I mean, Littlewoods is referred to in the...
It is.
You know, we've been through this, and it's, I mean, fairly sufficient to refer to the judgment.
If your Lordships go, I want to take your Lordships first to the Advocate General. Your Lordships see that the Advocate General here was Advocate General Waterlet, who's a former judge of the court.
Yes.
He was, in fact, one of the judges in Metal-Gesellschaft. So, and indeed was the judge rapporteur in that case. So the Advocate General, in this case, may probably be considered as something of an authority in this area. Can I just ask your Lordships first, in relation to the Advocate General, to glance at the submission made by the various participants between paragraphs 13 and 18 of the Advocate General's opinion. It starts at page 1363, internal page 1325.
Yes.
Just picking it up at 13, if I can read your Lordships 13 to 18. Written observations were submitted by the applicant Romania, the Kingdom of Spain, the Portuguese Republic and the European Commission. The applicant Romania, the Kingdom of Spain and the Commission made oral observations. The applicant observes that the European law precludes national legislations which limit the amount of damages, loss of profits, which are payable in full to an individual who has paid tax, which is contrary to European law, by allowing interest only from the date of the claim for repayment and not from the date of the payment of the illegal tax. Romania observes that the Romanian legislation permits full compensation for the loss suffered by taxpayers who have been obliged to pay a tax subsequently found to be illegal. In addition, according to Romania, the member states have the right to lay down conditions for allowing interest and compensation for the loss caused to individuals by the payment of taxes charged contrary to European law, in accordance with the principles of the effectiveness, equivalence and proportionality of remedies. The Kingdom of Spain considers that European law does not, in principle, preclude provisions of national law which limit either the compensation that may be obtained by an individual whose right is infringed, or the amount to be repaid by reason of a payment that was not due. According to the Kingdom of Spain, there is inconsistency with the principle of effectiveness only if the interest payment was so small that it would considerably limit, render meaningless, or reduce to zero the right to payment of interest. The Kingdom of Spain considers that the payment of interest from the date of the claim for repayment of the illegal tax does not render that right meaningless. The Portuguese Republic considers that it is for the member states to lay down the details of the amount which the individual is entitled by reason of the infringement of the European Union law, provided that those details do not entail a substantial reduction in the amount to which the individual is entitled and cannot be regarded as an obstacle to the exercise of the same right. According to the Commission, a provision of national law which, as in the present case, limits considerably the taxpayer's right to recover losses incurred as a result of the non-availability of the amounts illegally levied is not consistent with the principle of effectiveness. And your Lordships will note what the Commission says. And your Lordships will also note what was said by Spain and Portugal. Because in our respectful submission, there is a similarity between the positions advanced by especially Spain and Portugal and the analysis of the Advocate General in Littlewoods itself. I've already suggested it may not be a coincidence, given the timing of the Advocate General's opinion, which would have come out at the time Spain and Portugal were putting in the submissions, and the Court of Justice's decision wouldn't have. Now, just going back to the Advocate General's opinion and looking next at paragraph 20, your Lordships see there that this was a repayment claim rather than a compensation claim. And then, in that respect, IRMI is on all fours with the present case. And then one has this useful overview of the development of the law on this issue. And if I can just take your Lordships through this, because in our respectful submission, this is very helpful. It has long been established that although there are no provisions in European law concerning the repayment of national taxes incompatible with European Union law, the right to obtain repayment of such taxes is the consequence and complement of the rights conferred on individuals by the provisions of European Union law as interpreted by the Court. The Member State is therefore required to repay charges levied in breach of European Union law, the right to repayment being a subjective right derived from the legal order of the European Union. Given the lack of European Union law rules on the subject, it is for the domestic legal system of each member state to designate, in accordance with the principle of procedural autonomy, the courts and the tribunals having jurisdiction and to lay down detailed procedural rules governing actions for safeguarding rights which individuals derive from European Union law, provided first that such rules are not less favourable than those governing similar domestic actions, principle of equivalence, and second, that they do not render virtually impossible or excessively difficult the exercise of rights conferred by European Union law, principle of effectiveness. In addition, contrary to the arguments of the Kingdom of Spain and the Portuguese Republic set out in points 16 and 17 above, although the principle of procedural autonomy leaves it to the domestic legal system of each member state to determine the procedural remedies for safeguarding rights which individuals derive from European law, that principle cannot have the consequence of restricting or undermining the substance of those rights. Although it was an established principle that national taxes incompatible with European law were to be repaid, it was uncertain whether a member state who had received tax contrary to the provision of the European Union law had an obligation to pay interest on the principal sum repayable. Accordingly, in Ansalda Energia, the payment of interest was considered to be an ancillary question to the payment of the tax, which was incompatible with European Union law, and it was for the national authorities to regulate that question by applying their domestic rules concerning the rate of interest and the date from which interest was to be calculated. That approach could be understood as leaving essentially to national law the question not only the method of calculating the interest on the tax to be repaid, but also the question of the actual right of the taxpayer to receive interest. Although at paragraph 86 of the judgment in Metal-Gesellschaft, the Court repeated that the payment of interest on taxes improperly levied was an ancillary question, it nevertheless found, in relation to that particular case, that the claim for payment of interest, covering the cost of loss of the use of the sums paid contrary to the European Union law, was not ancillary, but was the very objective sought by the applicant's actions in the main proceedings. According to the Court, the infringement of the European Union law in question arose not from the payment of the tax itself, but from the fact that it was payable in advance. In those circumstances, the award of interest represented the reimbursement of that which had been improperly paid and appeared to be essential for complying with the rules of the treaty. Consequently, the applicants in the main proceedings were entitled to interest on the sums paid in the period from the advance payment of the date to the date when it fell due. It would no doubt be possible to imagine limiting the Metal-Gesellschaft judgment to the specific facts of those cases, that is to say, the advance payment of tax. However, in FII, the court held more generally with regard to the payment of discriminatory taxes that where a member state has levied charges in breach of the rules of European Union law, individuals are entitled, and again we have this, to reimbursement not only of the tax unduly levied, but also of the amounts paid to that state or retained by it which relate directly to that tax. Furthermore, we have paragraph 28. In the recent judgment in Littlewoods Retail, the court, following the case law in Metal-Gesellschaft and Presskelemen in the FII group litigation, held that the member state had an obligation to repay with interest amounts of tax levied in breach of law. The court added that although it was for the internal legal order of each member state to lay down the conditions in which such interest must be paid, referring to the rate and methods of calculation of the interest, the national rules should not deprive the taxpayer of an adequate indemnity for the loss occasioned through the undue payment of tax. And my lords, just pausing there, your lordship sees in the course of those passages, and more particularly paragraph 22, the express rejection of the arguments of Spain and Portugal. As your lordships saw, Spain and Portugal had argued that the principle of procedural autonomy gave the national legal systems a degree of latitude in determining what level of interest was appropriate, even if it did not reflect the full time value of the money. But as your lordships see, the Advocate General in Irimi clearly rejected that, making the point that the principle in accordance with which it is for the domestic system of each member state to determine the procedural remedies for safeguarding rights cannot have the consequence of allowing the national system to restrict or undermine the substance of English or EU law, and that right, as the AG says, included a right to reimbursement of interest, as became clear following Metal-Gesellschaft and thereafter FII and Littlewoods. And then, if your lordships look next at paragraph 29...
Can I ask, I mean, obviously, in this case was about statutory interest payable under Romanian law, and the problem was that interest was only due from the date when a claim was made for reimbursement. Is there anything to indicate that this wasn't a simple interest calculation?
I don't know whether it was simple interest. I don't know what the argument was in that case. But the point about that case is what they said was that there was a structural problem which prevented you getting adequate interest. Now, what adequate interest is...
So you weren't getting any at all for a large part of the time during which you've been out of your money.
With respect, that is right. You were getting some interest, but you weren't getting adequate interest. You were not. The point is that this statute was held to be a problem, even if you made your claim 3 days after they took the amount. In other words, you could have cases in which there was simply 1 day of interest that you were not getting. The point that they made here was that that is not good enough.
I mean, in a sense, what's useful for you particularly is the Attorney Advocate General's interpretation of Littlewood as treating the question of effectiveness as incorporating the adequate indemnity point, which means reimbursement of and takes on board Metal-Gesellschaft. So to that extent, it sort of meets the sort of point I was putting earlier on.
Your Lordship, with respect, is entirely right. This is a statement in much clearer terms than I could make of what our position is.
I mean, the facts are very different, obviously.
The facts are very different. And obviously, in every single case, the court will have to decide whether there has been an adequate indemnity. In this case, in Irimi, it was very easy because they had a structural limit which ensured there wouldn't be an adequate indemnity. In our case, the facts are very clear. We've been paid less than 24%. Can I just read your Lordship's paragraph 29? In my opinion, the right to interest representing an adequate indemnity for the loss occasioned through the undue payment of tax contrary to European law ranks equally in consequence of the Littlewoods retail judgment with the right to repayment of the tax and is therefore a subjective right derived from the European Union. Now that is the point that I have been making to your Lordships about the rights ranking equally. And if your Lordships ask yourself, if you're dealing with equal rights and no one would dream of saying that paying less than 25% of overpaid tax was enough, how can it be that paying less than 25% of the interest in relation to this right of equal standing is enough?
And we have the adequate compensation point in paragraph 26 of the judgment.
Indeed. If I can just take your Lordships to...
Well, we've got it. I mean, we've read all
Okay.
I'm sorry, but one
you...
sees the strength of the point you're making, but this is simply applying Littlewoods to a different factual situation.
But it's applying it in the way that I interpret it, rather than the way that my learned friend interprets it.
But I mean, we get that from paragraph 26, as you say.
Of the judgment, because I think I've been showing you the Advocate General's.
Yes, I know. The Advocate General, I think, arguably goes rather further, because as you say, it's a particular pet subject of his. It's much more important to see what the court says.
So if your lordships go to page 1332 in the bundle,
Yes.
sorry, 1370, I'm so sorry, 1332 of the internal page.
It doesn't say anything about interest rates, does it? No. Or whether it's simple or...
That is assumed to rise.
No, that was not the issue in the case. So you don't have anything about... And just with respect to my lordships, your lordships will bear in mind that the issue in Littlewoods was not about simple or compound interest either. That is not the way the question was put. That was not the submission that was made by Littlewoods. Littlewoods didn't say we're entitled...
Yeah, well, we know that. We've got that point.
But that's why what matters is the test that they identify, and that's the adequate indemnity test. Paragraph 20 to 29, I don't know to what extent your lordships have seen this, whether your lordships will bear with me if I take your lordships through this again.
I think we saw it yesterday, so I seem to have marked all the paragraphs.
Right. Well, if your lordships have marked all the paragraphs, the key passage we would suggest here is paragraph 28.
Yes.
The reason the Romanian legislation, so perhaps paragraph 26 matters as well, where you get the point about the principle of effectiveness. What it requires is that there be an adequate compensation. For 28, the key passage there, it identifies the reason the Romanian legislation prevented an adequate indemnity for the loss occasioned through the undue payment of tax was that the extent of the loss depended in part on the duration of the unavailability of money. My lords, the extent of the loss also depends on the use value of the money. One wouldn't, to adequately indemnify the loss, or to borrow from the language of Lord Nichols in Sempra, to ensure that a fair and just result is achieved, one needs a calculation which A, runs over an appropriate period, B, uses an appropriate rate, and C, makes appropriate assumptions about compounding. And if the consequence of not doing that is that you compensate for less than 25%, it doesn't really matter whether the reason you didn't do that was because you didn't compensate for the first part of the period, or whether it was because you did one of these other things wrong. If the period is too short or the rate is too low, or an inappropriate decision is made about compounding, the loss will not be adequately indemnified. And we say, my lords, it is difficult to see why a provision that operates as a cap or limit on the rate or the amount of interest is any better than a provision that operates as a cap or limit on the time period for which interest can run. And that, we say, is why IRIMI is so important. It makes clear, if clarity was needed, that an adequate indemnity must compensate for the full extent of the loss. It's difficult to understand on my learned friend's case how IRIMI can be explained. Now, without taking your lordships to this, both Mr. Justice Henderson and the Court of Appeal all agreed with the understanding of IRIMI that I have been submitting to your lordship. Just for your lordship's note, Mr. Justice Henderson deals with this at paragraphs 264 to 270. That's core page 506 in the A9 bundles 3067 to 3078, 3076 to 3078, and the Court of Appeal deal with this at paragraph 97. And your lordships will notice, when your lordships go back to Mr. Justice Henderson, his observation, this is at paragraph 297, that the only material difference between Littlewoods and IRIMI was this. In IRIMI, it was plain on the face of the legislation that the statutory interest would be an inadequate indemnity. That was plain because it limited the period of time for which interest was going to run. And so there was no need to refer that matter back to the National Court. By contrast, in Littlewoods, the Court of Justice was not in the same position, and that was because at the time of the reference, the English court had not yet quantified the use value of the money in question. This is a question of fact, which the Court of Justice was unable to determine for itself, and so the court could only refer the matter back to this court to determine the extent of the losses, and in light of that, whether the statutory interest was an adequate indemnity. But, my lords, once the English court had determined the extent of the losses, as your lordship saw at paragraph 307 of Mr. Justice Henderson's judgment, the English court finds itself in the same position as the Court of Justice in IRIMI. And we submit, my lords, I don't think there's any dispute about that, that if the test we identify is right, test is adequate indemnity in the sense in which Mr. Justice Henderson and the Court of Appeal said it was, there is no, sorry, let me put that slide. HMRC do not dispute that if that is the right test, the indemnity they've provided is inadequate. Now, my lords, as a postscript, it may just be helpful if I showed your lordships how in a more recent case, the Advocate General in this new case interpreted IRMI, and that case is Wortman. If your lordships can go to A5 at tab 50. This case is the latest word, A5 tab 50. The Advocate General's opinion in this case was given in September 2016, and the court gave its ruling in January of this year. Wortman concerned anti-dumping duties, charged under regulations subsequently held to be invalid. The paying company recovered the duties, but there was an issue as to whether it was also entitled to interest. That was the main issue in the case, and it doesn't concern us for present purposes. The upshot was that the paying company was entitled to interest under the principle established in Littlewoods and other cases. And I should mention that there was no question in this case about the rate of interest or about whether the interest should be compounded. But it seems there may have been a question about the period over which the interest was payable. Can I just invite your lordships to go to paragraph 69 of the Advocate General's opinion on page 1982. That's bundle page 1982. Paragraph 69. Nor, in my view, are there persuasive arguments for concluding that the dies a quo for the calculation of interest must be the date on which the Brosman judgment was given, or as a last resort, the date on which the claim for interest was brought before the court. As regards the latter view, in IRMI, the court held that EU law precludes a national system which limits the interest granted on repayment of a tax levied in breach of EU law to that accruing from the date following the date of repayment of tax. So as your lordship sees, the AG here appeals to IRMI to resolve a question about the date from which interest should be calculated. And then we have this, paragraph 70, where the Advocate General gives his reason for this. The reason for that ruling in IRMI was that if the opposite rule had been accepted, the taxpayer would have been deprived of compensation commensurate with the loss suffered as a result of the payment of the tax that was contrary to EU law, a loss which depends on the duration of the unavailability of the sum unduly levied in EU law during the period between the date of undue payment and the date of repayment. And so your lordship see the Advocate General interpreting IRMI as requiring that the payment be commensurate, or the adequate indemnity, compensation, be commensurate with the loss suffered. Your lordships will recall the use of that word commensurate is in fact exactly what Mr. Justice Henderson said in his gloss. The lordships will recall the Court of Appeal said it was better not to have a gloss, but the Advocate General here, on the basis of IRMI and Littlewoods, gives exactly the same gloss. It's almost as if the Advocate General has been reading our papers, my lord, but he hasn't. I don't want to go too far with this because this is not a pronouncement of the Court of Justice. And subject to your lordship, I wasn't going to go to the decision of the Court of Justice because it doesn't take matters forward. The Court did agree with the Advocate General's disposition of this case, and specifically with his reasoning on the main issue, and agreed that interest should run from the time duties were paid. But the Court did not mention IRMI or the Advocate General's explanation for it, so we just have the Advocate General. But in my respectful submission, notwithstanding that, again, just as IRMI is a helpful gloss on Littlewoods, so too what the Advocate General in Wortman says is a helpful gloss on Littlewoods. And my lords, subject to anything your lordships have for me on issue 2, that was all I was proposing to say about it.
That's very helpful, Mr. Benevit. It may be sensible if we adjourn now, and provided we're doing fine on time if we have to deal with the other issues.
That may depend on my learned friend. So far as I'm concerned, your lordship have gone through 2 of the issues. We have 2 to go. They each have a sub-issue, but we do have 2.5 days to go.
Quite.
I was intending to reply to just on those 2 matters.
Okay. And I think, in fairness, just so neither of you is taken by surprise, issue 1 is Mr. Rabinowitz's appeal. And I think, in fairness to Mr. Rabinowitz, we should give him the last word on that.
Yes,
But I just think it's right you both know that's what we've proposed. Good. Well, then we'll resume again at 2 o'clock. Thank you. Court's now adjourned.